Good afternoon, everyone. My name is Kathy Purdy. I'm the marketing manager at Schoeneck King. I'd like to welcome you to this week's coronavirus update and discussion on continuing legal and practical issues related to COVID-19. This week's moderator is going to be Adam Masterleo. He's filling in for Pete Jones this week. Two quick housekeeping items before we do get started. If you have any questions, please enter those through the Q&A box located at the bottom of your screen. And once the webinar has concluded, if you would take a moment to complete the brief survey, we would greatly appreciate that. So to get things started, I'm going to hand it over to Adam.
Kathy, thank you so much. Welcome everyone to this week's installment of Schoeneck King's weekly coronavirus webinar. I was talking to Pete getting ready for this, and it's really amazing that we've been doing these for months. And you'd think that topics would grow stale and we'd run out of material to talk about. But even now, as we begin September, we're getting new updates, new information on a weekly basis that is relevant for businesses all across the state. So thank you again for joining us. Today, what we're going to do, we're going to go through a number of topics. We're going to start with an update on New York's paid sick leave law. Then we're going to get an update on some recent developments in higher education, followed by our weekly update on what's going on in Albany. Then we're going to proceed through a little bit of an update on possible litigation and litigation issues. And finally, we got some new guidance from the Department of Labor late last week that is relevant for how we respond to leave requests. So that's what we're looking for or looking to do today. But to get us started is Teresa Rusnick. She is an attorney in our Rochester office. Teresa has been an expert on the new New York State paid sick leave law. She's spoken on it a number of times. And we're grateful that she's joining us here today to talk to you about some frequently asked questions. So Teresa, please take it away.
Thank you, Adam, and good afternoon, everyone. As Adam said, I've spent some time looking at the New York State paid sick leave law, and I'm happy to share any insights I have with you today. I'm going to do a review of the basics of the law, what I'm referring to as the big three: use, carryover, and accrual. Those are the three things that you need to make sure you have right in your sick leave policies, or to the extent you're modifying existing policies to comply with New York paid sick leave, those three need to be correct as set forth in the statute: the use, carryover, and accrual for the leave. I'm then going to talk about some of the things I get questions on most often, so just collective bargaining agreements and how to draft a policy and how to integrate your paid sick leave requirements into your existing leave policies, which is probably the question I get the most. So there's different ways to do that, and I hope to go over a couple of them with you this afternoon. So brief review of the basics. The amount of paid sick leave that your employees are entitled to depends on two things: the size of your company and the amount of net income you had in the previous year if you have 4 or fewer employees. So if you have 4 or fewer employees and your net income is $1 million or less in the previous year, you have to provide your employees with 40 hours of unpaid sick time. If you have 4 or fewer employees and your net income is over $1 million in the previous year, then you have to pay your employees 40 hours of paid sick time. So I just want to stress there, even if you're very, very small and you don't have many employees, you still have to provide sick leave. It just may be unpaid in that instance, but this does apply to all private employers in New York State. If you have 5 to 99 employees, you have to provide 40 hours of paid sick leave. And if you have 100 or more employees, 56 hours of paid sick leave. And I mentioned private employers. At this time, we do not believe that New York paid sick leave applies to public employers because of the way the definition of employer is set forth in the statute. It excludes government agencies. So accruals of New York paid sick leave begin on September 30th. So we are just under a month. Use of PSL must begin on January 1, 2021. As expected, PSL use and availability tracking are going to have to be required. So you're going to have to keep track of how many hours your employees accrued if you're using the accrual method, and how many they used if you're using the accrual method and the front-loading method. There is a documentation requirement to make sure that employees can ask how many hours they have and how many hours they've used. One of the things I get the most questions about, and I'm just going to say it up front, we are still, as of this morning, waiting on guidelines from the New York State Department of Labor for paid sick leave. I do think when we receive them, they will clear up a number of these smaller issues like documentation and medical requirements and things like that, but we simply don't have it yet. The last we heard from the Department of Labor was that the regulations would be upcoming in the coming weeks, and we have not heard anything since then. At this point, I'm just hoping that they get released before September 30th, which is our effective date for the accrual to begin, if you're using the accrual method, but obviously stay tuned to that. We will absolutely fill you in on that as we get more information on it. A couple of other quick things about New York State paid sick leave. If an employee uses it, you need to make sure that they are returned to the position that they left, and that no one's retaliated or discriminated against for using New York paid sick leave. That shouldn't be news to anyone listening. Employers can either accrue or front load New York State paid sick leave. Like I said, if you're going to accrue it, it has to be at a rate of 1 hour for every 30 hours worked. There is an option to front load it, which you can do as of January 1st. You can also pick a different date according to the statute. You can pick a different date to front load the leave or to use as your calendar year for New York paid sick leave purposes. So if you wanted to use an employee's anniversary date or some other date that made more sense to the individual business, that would be fine as well. There is mandatory carryover between calendar years or accrual year length. There is some vagueness about how much leave needs to be carried over because the statute caps the use, or it allows employers to cap the use of paid sick leave at 40 or 56 hours per year, whatever the employer's maximum is. It's not necessarily clear that accrual and carryover are likewise capped. So while it might make sense that you could cap accrual at 56 hours or you could cap carryover at 56 hours, the statute just isn't as clear on those points as we would like it to be. So to the extent you are modifying a policy that caps carryover or caps accrual, that's something you just might want to flag until we get guidance to make sure that you're in compliance with the statute. There is a maximum minimum, as I'm calling it, or a maximum increment that employers can mandate employees use paid sick leave in, which is 4 hours. So you can allow your employees to use paid sick leave in increments of 1 hour, 2 hours, 3 hours, a half hour, 15 minutes, 4 hours, but you can't mandate that they use it in increments of 5 hours or longer. So if you have a policy that says PTO can be used, but only in increments of a day, then that policy is not going to work in the paid sick leave world. It's going to have to be modified. So paid sick leave can be used as soon as it's earned. As far as we know, there's no 90-day waiting period or anything like that. I know there is one under the New York City version of paid sick leave, but we don't so far have one under New York State paid sick leave. Sick leave can be used, as you would expect, for the treatment of a health condition for an employee or an employee's family member. The definitions there, to the extent that they exist, are very, very broad. I think we're looking at a pretty broad usage of paid sick leave when it all comes down to it. And then, of course, please keep in mind that paid sick leave can be used for something that has nothing to do really with illness, but when an employee or an employee's family member has been the victim of domestic violence, a family offense, stalking, or some other type of crime in that vein. So employees who are covered, I've been getting a ton of questions about whether part-time, per diem, seasonal, and temporary employees and student employees are covered, and they are. There's nothing in the statute that limits the definition of employee. If you issue the individual a W-2 form, you must currently assume that that person is covered by New York State paid sick leave and is allowed to begin accruing the leave. If you're looking at modifying an existing policy to incorporate paid sick leave, the law does allow you to do that as long as your existing policy satisfies the accrual, carryover, and use requirements of New York State paid sick leave. So you're going to want to pay extra special attention to those big 3 bullet points when you're looking at your policies. I see a lot of policies that meet the accrual, as in they give plenty of leave, but they don't necessarily meet the carryover. And then very few policies have the use, which is they don't state explicitly, how could they, because we didn't have paid sick leave when these policies were written, but they need to explicitly state, employees, you can use PTO for any purpose, including paid sick leave purposes, and then list the paid sick leave purposes so that employees know that they are getting that leave that they're entitled to. So those are some things to consider when you're modifying your policies. Please just be aware that nothing exists in a vacuum. Paid sick leave is going to impact other policies such as FMLA, federal contractors leave, your collective bargaining agreements, which I'm going to talk about in a minute, New York State paid family leave. So to the extent your PTO is reflected in any of those policies, you need to make sure your paid sick leave is as well if you're modifying your PTO policy to accommodate paid sick leave. So, I get a lot of questions about collective bargaining agreements. Right now, it's a pretty open field on collective bargaining agreements. There is language in the statute that says there's nothing that prohibits a collective bargaining agreement entered on or after September 30th from providing a comparable benefit, which is all well and good for those agreements being negotiated on or after September 30th. There's more of an open question about what you do with agreements that are existing that aren't necessarily up for renegotiation or collective bargaining within that time period. And so for those, I really encourage you to work with your attorney or your counsel on that, because that's going to be a facts and circumstances dependent analysis. One last thing I'll say about paid sick leave is documentation. You need to be aware of how you're tracking your employees' hours, even for your exempt employees, because employees have a right at any time within 3 days of their request to receive information from you about how much paid sick leave they've earned and how much paid sick leave they've used, both in this coming year and then in any prior calendar year. So those are going to be records you're going to want to keep for quite a while as we start getting into the years where paid sick leave can be accrued and used. So that's just a brief overview. There's much, much more to say on paid sick leave. If some of you were on the webinars I gave with a colleague, Andy Bobrick, last week and the week before, and you're interested in this topic, we do have those on our website. They're accessible through our webinars link. If you have any trouble finding them, just feel free to shoot me an email. Adam, I'm going to turn it back to you.
Teresa, thank you so much. And we've gotten quite a few great questions on the paid sick leave law and very specific fact-dependent questions. I know that we're not, you can't answer those now, but obviously we would encourage you all to contact your attorney if you have any specific questions about your business or your employees about what changes you might need to make. And Teresa and any of the attorneys in our labor and employment department would be happy to help you with that. So thank you, Teresa. Really appreciate it. All right. Next, we're going to move on to our higher education update. There's been quite a bit in the news about higher education institutions all over the country and here in New York State. So to give us that update, we have Gail Norris. Gail is an attorney in our Rochester office who spent many years as general counsel for higher education institutions. So Gail brings a wealth of experience and knowledge, and she's going to provide us with that update. Gail?
Thanks, Adam. Good afternoon, everyone. Yeah, as Adam said, I'm sure you've all read a little bit about what's happening in higher education as campuses go back to residential living and learning, and higher education institutions are continuing to struggle in the new COVID world in a whole bunch of areas. But today I'm just going to focus on three areas that have had some more publicity than others as students are just starting to get back on campus over the last couple weeks. The first is how to control and manage outbreaks. The second is, what schools are doing to try to communicate infection rates and some of the issues that have cropped up in sort of data tracking and publishing, and then how to enforce the safety rules once kids get back to campus. So with respect to outbreaks, like the rest of the world in COVID, the reactions of what's happened on campus have been variable. There have been some campuses that have reversed their decisions on reopening their campus to to personal instruction, in-person instruction. There's some that have some hybrid models that are continue to work, and there's some that are still fully opening up with living and learning live on the campus with varying results. As I'm sure you've read in the paper, there have been some instances of outbreaks that have been sort of fast and furious, but some schools have shown that schools can pause, keep students on campus as infection rates rise, return to remote learning so that students aren't going into classes, sort of restrict school activities, have students stay in clusters as much as possible, and have the infection rates come back under control so they can reopen again. That's University of Notre Dame is the one that's probably been in the news that's had that happen, where they're back now to being in-person instruction again after having shut down. And actually, this is very consistent with what Katie Anderson's going to talk about next, with Governor Cuomo's latest guidance on infection thresholds in higher ed institutions and when schools have to return to remote learning. So what schools are trying to do is a bit consistent with what the new guidance from the state reveals that Katie's going to talk about. One specific challenging issue that's cropped up in controlling and managing the outbreaks has been off-campus living, which there in different communities is a big percentage of students. This becomes a community issue as well, because the students are living and circulating in the local community, not as constrained to campus. And colleges are struggling with what you do with that. Obviously, the schools have less supervision for students who live off campus, and as a result, less vision about what's going on. And they're trying to figure out ways to stay ahead of what could be happening if there's parties or other kinds of things happening off campus that they want to make sure they hear about it sooner rather than later if it's going to cause infection rates to climb. And that sort of segues well into the issue of publishing data on infection rates. The communities in big college towns are interested in what's going on campus because it does have an impact on them, as do the students and their parents. So I think most schools have some kind of dashboard that's showing testing and positive tests and infection rates, but there are some schools that are receiving pressure to be more granular. People have asked about publishing information on how many students are quarantined, whether there's clusters, whether there's specific off-campus areas that could be impacted by the outbreak, and that's all causing some challenge for campuses because there is no standardized way to track infection rates in college students. Should employees be included in those rates is another issue. Does it matter whether the employee was infected, perhaps not while they were on campus, but while they were home? Is that going to skew the rates? Again, off-campus housing, there's been issues raised about what happens if a student living off campus goes to get tested through their drive-through drugstore testing site. Will the school even know if that test is positive? Will it depend on what the student tells the contact tracer for the Department of Health about whether and to what extent they've been on campus, about whether the campus will even be alerted as the contact tracing Department of Health employees take over? And that's caused a little bit of concern. There obviously are privacy concerns that are all wrapped up in this. And I think sort of for now, as schools are working their way through it, anybody who's reporting dashboard issues on infection rates should be clear on how and what data they're collecting, because there may be things that are missed that are potentially, may skew the accuracy of the dashboard data. And the last area and the most sensitive one is what schools are doing to discipline or sanction students for COVID safety violations. And again, this is also a community concern in those big college communities. Most schools have taken the approach that violations of safety plans at colleges are not disciplinary sanctions that would require transcript notations, such as, you know, a academic honesty issue, for instance. So we don't have the formality of worrying about the impact on records of disciplinary sanctions. But schools are pretty serious about obviously wanting to enforce safety plans because it's got a consequence to the community and to the viability of the school's reopening plan. Last week, Ohio State announced 228 interim suspensions so far in this semester. I don't know how long they've been open, but it can't be long, for COVID safety violations. And there are many other schools that are very transparently showing their strict enforcement of the safety plans. And you can certainly understand why that would be and why it's important for students to follow them, but there have been some backlash. There was a scathing editorial, I can't help but quote this to you, in the student newspaper at UNC Chapel Hill, which was one of the schools that had to shut down for a while because of a big outbreak. And the editorial stated, and I quote, "University leadership should have expected students, many of whom are now living on their own for the first time, to be reckless. Reports of parties throughout the weekend should have come as no surprise." So there is a little bit of a backlash and finger pointing that goes back to the schools that are saying you should have known, you should have, you know, maybe made some of the safety rules clearer. We're hearing that a lot because the rules are pretty wide ranging. And there's always specificity that probably could continue to be provided as we're making this up as we go. So schools are trying to balance being transparent about how important it is that safety plans are enforced versus not getting the backlash from big disciplinary action that can come from students and their parents. So the best practices, that some of these could be translatable to businesses too, for what you do for safety violations. So far, what we've come up with would include, you know, first of all, ensuring that sanction messages are accompanied by statements that focus on the need to educate students of the impact of their behavior, both on the campus and in the community. Because the one thing that makes this unique for other types of behavior issues on college campuses is that it's a community health issue. And that, you know, schools should partner with student organizations to help with that communication. That the safety rules are there because they do have a public health issue. They're required by the state. They're not made up by the school. And having students communicate that to other students is always more impactful than having it come from the administration. And then lastly, you know, the message can be supported by data, because unfortunately, college-age people, you know, we've now seen more and more can become severely ill with COVID, despite maybe some thinking to the contrary earlier in the pandemic, and that college-age students are within the age group where infection rates are rising or are still too high. And sometimes communicating that to students and letting them know this is your issue right now across the country, this year, the group, and you need to be careful can be helpful. And that's my updates for now.
Gail, thanks so much. I know you and I have both worked on a number of higher ed plans, and there's that delicate balance between making sure you have the required elements and then implementing the elements and trying to make sure everybody's complying. So thanks again for that. Next, we're going to turn to a familiar face for those of you who attend these webinars weekly. Katie Anderson from our Albany office is going to give us her weekly what's going on in Albany. So Katie, take it away.
All right, here we go. We always have a lot to cover, so I'll do it, you know, the best that I can. First thing, we'll start with our, seems like weekly segment as well, travel advisory update. There were no states removed, but added to the list this week were Alaska and Montana. I took a look at the data that was published this week. It actually appears that some places may be coming off the list next week. So we're looking at potentially Florida may be coming off the list, which is shocking. It's shocking to me. I really expected them to be on the list until December, but I don't know that for sure. This was just me taking a look at the list. So next week we could be seeing some real potential shakeups. One other thing too, before moving on, I saw a number of questions in the chat about the payroll tax deferral, the memo that came out from the IRS. Our firm is the tax group is putting out an information memo on that. It should be coming out today, according to my sources. And if you have other questions on that, get in touch with any person in the tax group. I know that Erica Wood covers that a lot. You can reach her at ewood@bsk.com. So just a plug for that. I'm turning also to looking at these higher education updates of the guidance that came out late last week, about when colleges have to close down. And I will touch on Oneonta at the end of this. No worries there. But the first thing, to look at here is colleges and universities have to go to remote learning for at least 14 days if the lesser of the following occurs. So it's you either have 100 individuals test positive or 5% of the total on-campus population tests positive within a 14-day period. So that's a small number. That number is trying to keep the infection rate basically below or around 3% for the area, based on what I was reading out of the governor's office. So, it's at 100 individuals or 5% of the total on-campus population, whichever's less. Total on-campus population, it includes all faculty, staff, students who are on campus and off campus. That is, quite a broad definition, but, when you look at a campus like SUNY Oneonta, where there's a significant number of students that are off campus, that is, that's why the developments that have occurred there have occurred at this point. What does this all mean? I was having a great conversation with my mom actually yesterday about this, where she said, a lot of these places are remote already. What does this mean that it's all going to be, going virtually when a lot of classes are being offered virtually? It means that there's no in-person athletic activities. If there were any to begin with, there are no extracurriculars. Classes that were, all classes, I put in asterisks there because I will discuss that in a second, are, turned to be remote. And then other non-essential student activities must be suspended. And the takeout and delivery of food has to be, occurring. Looking at this exception for all classes must be remote, the college itself or the university may work with the local health department to allow certain classes or in-person activities, they call it, to occur. So that includes your clinicals, laboratories, or research activities to be conducted in person. Basically anything that would be critical, anything that's research, or you need to be in person for a professional license. Those types of things will be allowed to continue if public health and safety, may be maintained. So you have to work in conjunction with the local health department here. That's going to be crucial. This last bullet, it's this real question of this impacts your on-campus life, but what about off-campus life? I don't know. The guidance really does not address off-campus life. It shuts everything down on campus, but the problem that we're seeing is, the parties. It's all of those things that we were all a part of at one point in college that suddenly have to have the valve shut off. And that's difficult. And Gail, I think, did a tremendous job discussing what tactics can be used to help alleviate that. when do things go back? That's a really a big question of this. When do things go back under this 14-day thing? Well, after 14 days, either the state and local Department of Health, they evaluate if the community spread has been effectively contained. If the community spread has not been contained, then there will be additional mitigation measures that may be required. I don't know what those are. They are not clarified in the document. They are not discussed. It just says additional mitigation measures. So if, we have this test right now with SUNY Oneonta, we may see additional mitigation measures, but we don't know at this point. This final part is very important to take a look at. So if clusters of COVID-19 cases develop on campuses that don't necessarily rise to that threshold of the 100 cases or 5% of the total on-campus population, the local Department of Health may work with the State Department of Health and require an institution to transition from to a remote format and limit on-campus activities. So this grants local departments of health and the State Department of Health broad power to really go over and change what's happening on campuses if there's a cluster of cases that develop. I don't know what that will mean. I suspect we will watch it develop before our eyes on a lot of campuses, which is not extremely helpful for trying to figure out how to prepare for that. But I expect that it'll be a lot of the same, everything is still remote. But again, we don't know that for sure. And finally, I'll touch on Oneonta because I've been asked this question a lot over the past 2 days. And it's right now, Oneonta State, for those who don't know, has been sent basically the COVID SWAT team. They have gone to this remote learning function. And there are 3 rapid testing sites set up that are going to be set up in Oneonta as of tomorrow. They're free of charge to go and take a test. And the question that's been asked is Oneonta going to become New Rochelle-like containment zone? And for those of us, who March feels like either yesterday or a year ago, that containment zone was set up at the very beginning of this pandemic to try to stop the disease from spreading out in New Rochelle. I don't think that is going to be on the table at all. We have so much more testing at this point. That's really the crucial thing for how we're going to contain this. So I don't think that we're going to see something like that coming out in Oneonta, in that area. Just as a, that's my take on it. And I think it's worth, noting and looking at that and looking at the rapid testing sites that are being set up in those areas. And this is also demonstrating what may happen in other places that have an outbreak. I think we're going to see, rapid testing sites set up and the expectation that people will be tested. I have one final note. I wrote this down for those who are interested. Mayor Bill de Blasio just announced that New York City schools will be delaying in-person learning until September 21. So that was just announced a few minutes ago. And with that, I am done. Thank you, Adam.
Katie, thanks so much. Really appreciate your weekly updates. There's always news out of Albany every week, so thank you again. All right, we are now going to switch gears a little bit, and we're going to talk about litigation risks. I know that we do these updates on litigation on a relatively frequent basis. I think it's always helpful for businesses to understand what their potential exposure is and how other businesses are dealing with these issues. So today we're going to have Dan Pouts, who's an attorney in our Syracuse office in the litigation department, give a little bit of update on this. Dan's talked on this webinar a number of times. So take it away, Dan.
Thanks, Adam. I appreciate it. I always, while you were giving my introduction, I always kind of feel like the Grim Reaper when I come on these things because I'm talking about either suing or being sued, neither of which things anybody ever wants to talk about or looks forward to. But as I mentioned in one of the prior presentations, it comes to as no surprise to any of us that there have been hundreds, if not thousands, of lawsuits that have been commenced, at least in some way relating to the COVID-19 crisis. And what I want to talk about today, because it's something that may affect and is affecting a number of our clients, are class action lawsuits that have been filed as of late. And I know many of us, if not all of us, have heard that expression, class action lawsuits, but a lot of us don't understand exactly what it means. Basically, it's a lawsuit that's commenced by an individual or a small group of individuals that are on behalf of a much larger group. And there's certain things that you need to show in order to qualify to be a class action. And basically, you need to establish that the number of people that are affected by this makes it too impractical to handle them on a one-off basis. And that there are common questions of law and fact that pertain to all of the members of the class. And that these claims made and the defenses made against these claims are common and typical of everybody in the class. So when we talk about class action cases, that's essentially what we're talking about, an action that's commenced by a small number of people on behalf of a larger number of people that are what's called similarly situated. So that kind of as the backdrop, I want to talk about a few key areas that our clients have found themselves involved in on one side or the other of recent class action lawsuits that have been filed. The first is related to the PPP as part of the CARES Act. I know most all of us are familiar with that. At least we've heard of it. A lot of us have received PPP money. The class action suits that we've seen have been commenced by small businesses against banks or other lending institutions. And basically the crux of the suit is that the banks had an obligation to process the loan applications on a first come, first served basis. And what the plaintiffs are claiming is that it didn't happen, but instead the banks elected to process the bigger, more lucrative loans, regardless of the timing in which those came in, because the banks, of course, would generate more revenue based on the size of the loan. And the plaintiffs are claiming that because the bank, I suppose, took these applications allegedly out of order, that they were blocked out of funding. And one thing to keep in mind is that we all know that there was a subsequent round of PPP funding. The lawsuits that I've seen with respect to these issues all pertain to the first round of funding back in the spring. So there's a number of defenses. And again, keep in mind as I'm talking about these cases are just barely off the ground. So we're familiar with the claims and we're familiar with the defenses, but we don't know at this point how persuasive the claims or the defenses are going to be. But with respect to these PPP loan lawsuits, the most common defense that we've seen is that the CARES Act, of which PPP is a part of, doesn't provide for a private right of action. In other words, I can't sue an individual or a business because they allegedly didn't comply with the CARES Act. That's the argument. Remains to be seen whether or not a court will accept that argument. Another argument, a defense that we've seen in the PPP cases, is that the banks are not in fact obligated to process these applications on a first come, first served basis. So in the absence of proving that the bank actually represented to you that they were going to do it and process the applications in that order, it's possible that there's nothing on which the plaintiffs can rely on that mandates the banks to do it that way. Also, the last defense that we've seen, as I alluded to earlier, because these lawsuits pertain to the first round of funding, a lot of these what's called putative class members, they may have gotten funding in the second round, which means that they really didn't sustain any damages. And on that basis, their claim may not be viable. So that's one area. I mean, obviously we represent a number of lending institutions, and that's one type of these class action lawsuits related to COVID that we've seen. Another is based on price gouging. I know we've seen a number of these stories in the paper about these e-commerce platforms charging insane amounts of money for, regular, either protective equipment, face masks, hand sanitizers, or just your routine household cleaning products. We've seen lawsuits, class action lawsuits filed against Shopify and other of these large e-commerce platforms. Again, the defenses that are being asserted in these cases, although it's still very early, is that we've seen arguments on behalf of the individual sellers and the platform saying, hey, look, it's not price gouging. We charge these prices because it accounted for the increased production and operational costs, which, eventually they'd have to prove that as a defense, but that's something that's being offered at this point. They're also the platforms, the e-commerce platforms themselves are arguing that they're not obligated to control what their sellers list their products for, that's on the individual sellers, not on the platform. So that's an interesting line of cases that I know that we've all read about, and I'm curious to see how those shake out. Another area that I'm sure we've all read about are class action lawsuits pertaining to or seeking reimbursements for tickets or memberships. Airlines, your stub hubs, your ticket exchange companies, sports teams, entertainment venues that host concerts. They're all being named. Many of them are being named in class action lawsuits for allegedly refusing to provide adequate refunds based on COVID-19 related cancellations. We've also seen these claims made against gyms or amusement parks. Members of these places are saying that, well, the gym was closed down for 5 months because of COVID, yet I'm still on the hook to pay my dues. So there are a number of defenses available. The biggest one is that we've seen is the credit versus refund issue. You may be aware of this because you may have gone through this yourself, but many of these, particularly the third-party ticket brokers, they've offered credit, sometimes in excess of 100% credit, as opposed to giving refunds. For example, there was a line of cases about March Madness, the NCAA games. StubHub was offering, I think it was 120 or 130% credit as opposed to refunds. And there are many people that saying that's not adequate. I'm entitled to a refund. And the most popular, and it's a pure legal defense that we've seen in these cases, is that you may not know this because not everybody reads the fine print, but when you buy an airline ticket or you buy a ticket to a sporting event, you're agreeing to a number of terms and conditions. And almost always one of those terms and conditions is that you're agreeing to what's called a mandatory arbitration clause, which means that if there's a dispute about your rights under these tickets, you're required to go to arbitration as opposed to going to court, which of course a class action lawsuit is. So that is a defense that we're seeing put forth in a lot of these ticket cases. Also, as I'm sure our highly qualified labor and employment colleagues would speak to, there's been a ton of class action lawsuits in the employee employment realm. Some of them are negligence cases relating to an alleged failure to provide adequate PPE or otherwise maintain a safe working environment. I've also seen at least one case filed on behalf of a class that's alleging that they've been wrongfully denied paid sick leave to which they are entitled. And these cases are interesting in the labor and employment realm because not only are they seeking compensatory damages, which is money, of course, they're also seeking what's called injunctive relief. And they're asking the court to order that their employer implement these measures and make the workplace safer, at least as that term is defined by them. Particularly with respect to the negligence claims, what I'll call the unsafe work environment claims, the defense of those claims is going to be really interesting because, all of us have witnessed, Katie done a spectacular job of giving these updates. And the one thing that's clear is that there's continuously evolving guidance on a lot of these issues. So in a negligence action, you have to prove that someone took an unreasonable action. And all of us can agree that based on the guidance and the increased information that we've gotten over the last 5 months, what is reasonable now, or what was unreasonable now, may have been reasonable back in April. So that's an argument in a defense that's going to be very interesting to see, how courts or juries accept those arguments. And to cap it off, to continuing with the higher ed theme that Gal and Katie both touched upon, as I'm sure you have read, there are multiple class action lawsuits across the country by students or sometimes parents on behalf of students, alleging that the colleges and universities, because of their shutdown in the spring, moving to online learning, that they deprive the students of the in-person education and the college experience that they had promised to provide. And they're claiming that even these partial refunds are completely inadequate. One recent update, very recent, that we saw was a district court out in Arizona actually dismissed one of these cases. But the reason for the dismissal was not on the merits of the case, meaning that the higher ed institution provided a comparable product. They dismissed it because of basically a technicality that when you're suing a municipal entity or state entity like they were doing there, they failed to provide adequate notice of claim. So we still don't have any decisions on the merits of whether or not these suits against the colleges and universities are going anywhere. But in terms of the actual claims made, most states, I mean, New York being one of them, bars sort of general educational malpractice claims. And in the case of a contract claim, a breach of contract theory, these plaintiffs are going to have to show that the school breached a specific obligation. In other words, they promised to provide a minimum number of credit hours or a student to faculty ratio, and that they failed to do that by transitioning to online learning. And of course, the defense that we've seen most frequently is that the benefit of the bargain for purposes of higher ed is the credit hours. And regardless of whether they receive the credit online or in person, they receive the credit hours. So again, all interesting things to keep an eye on. If any of these cases affect you or you get notice of them or you may be involved in them, please reach out to your favorite bond attorney and we're happy to walk you through it. Thanks, Adam.
Dan, thank you for that update. Now, I know that we've reached our time, but I want to give a quick update for everyone on the guidance that we received from the Department of Labor over at the end of last week. So you may recall, if you were on this webinar last week, I talked a little bit about leave requests from employees related to childcare issues, specifically associated with school closures. At the end of the week, the Department of Labor issued some guidance as it relates to those requests under the Families First Coronavirus Response Act, and I think it's important for us to go over those with you today. So by way of very quick background, the Families First Coronavirus Response Act, the FFCRA, provides for paid leave in certain circumstances. And there's two types of paid leave that are provided. One is emergency paid sick leave, and the other is expanded FMLA leave. Both types of leave are available when an employee needs to care for his or her child because the child's school or daycare is closed due to COVID-19, or their paid child care provider is unavailable. So in the context of school reopening here in New York, a lot of parents are saying, my child is only going to be in school 2 days a week. The district is using a hybrid model. So I should be entitled to paid leave on the days when the child has to be at home with me. And up until Friday, the answer wasn't entirely clear about whether that type of intermittent leave would be available. There was a case earlier in the month from the Southern District of New York that said that earlier DOL guidance on intermittent leave was invalid, but it wasn't clear the application of that case. Now we know from the Department of Labor what they intend. So the Department of Labor has been releasing these FAQs in question and answer format throughout the course of the last 5 months. And there's 3 new questions that were released on Friday, all dealing with this specific issue. The first question was, if my child is in a hybrid learning model and will be in school 2 days a week and at home 2 days a week, am I entitled to FFCRA leave? And the DOL answer to that question was yes, you are entitled to FFCRA leave, so long as you need the leave to actually care for the child during that time and there's no other suitable person available to provide childcare. So the DOL cleared up the confusion. Employees are entitled to leave under the FFCRA if their child is in school a couple days and home for the other days. The second question was, well, what if my school has given me the option to choose whether or not my child goes remotely or in person? The DOL gave us the answer to that question, and they said no. If you are making the choice to keep your child home, then you are not entitled to leave under the FFCRA. So that's a good development for employers. The third question was, what if my school is starting completely remote with no option for in-person, but they may at some point go to in-person education? Am I entitled to the leave now, and will I be entitled to it going forward? And the answer was yes, you're entitled to it now, but if at some point the school has in-person education available for your child, at that point, your entitlement to the FFCRA leave has to be reevaluated. So given these new answers, which aren't great for employers, we have a very basic suggestion, and that is make sure that you're documenting employee requests for leave on this basis. So if an employee is requesting leave because their child has to be in school, you should have them put that in writing. I have suggested before on these webinars, and I know many of the attorneys in our labor department use forms for these types of requests that employees must fill out before they obtain leave. That way, the employee will have to say in writing specifically what they're asking for and why they're asking for it, so you can make sure you're complying with the applicable law. So that is it for our update this week. Thank you all for attending, and we hope to see you next week on our webinar. Thank you again.